These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
What we're going to do is discuss taking control of property, which isn't exclusive to real property. We could be talking about vehicles or anything else. Okay?
Understand when he talks about real property, speaking of real estate as opposed to movable goods like a car or something. So real property is different than movable goods.
Okay. So there's 3 elements to perfection of a security interest. Okay? If there's an outstanding liability or an account, the account must be settled. The title, documents of title, must be clear in that they show the only lien holder to be you or the party who is perfecting the security interest. 3, possession. You control through possession. If you control through title and possession, then you have what's called a perfected security interest. Okay? So let's first take a look at settling the account. We were just discussing, or we've been discussing over the last couple months, using IRS Technical Support Division for settling accounts. How many are familiar with those processes? Okay, not everybody's familiar with them? Okay. So those of you not familiar, we've done sessions, actually the February session of the Living Temple, we went into detail on settling accounts using A for V. Now, if it's real property, I would probably use a bonded promissory note, but to use bonded promissory notes, you must have established your account with the Treasury, meaning you've done the BC bond with the birth certificate accepted for value, you've done indemnity bonds, set-off bonds, and then you can issue bonded promissory notes off of the set-off bond, okay? If you haven't done that, then you may be looking at getting some kind of a statement. If it is a statement with a coupon, that's preferable, and then doing the A for V process that we've discussed in the past. Now, because of the nature of property being that if you go into dishonor on the account, it's going to escalate with the lien holder a process whereby they're going to attempt to perfect a security interest by possession of your property, meaning they're going to try to take it away. Right?
Hey,
you stop paying your car payment, what's going to happen? They're going to take it away. If you stop paying for your house, what are they going to try to do? Take it away.
Might be important for you all to clearly understand what a security interest is, because he's using that word a lot. And a real simple definition for you is a lien on personal property created by an agreement. So when he's talking about a security interest, try and replace that with that definition. Might give you a little better understanding.
Say that again.
A lien on personal property created by an agreement.
Okay? So, the first presentment we're going to make is going to be, in this particular model, this is not the only way. How many ways are there?
375,000.
Okay. So this is one way. Because of the nature of property, I'm not going to just send in my payment instrument or my tender for set-off to Technical Support Division of IRS. I'm going to make it a process. Now, it's not a three-step process, meaning I'm not going to be doing notice of fault, notice of default, or anything with the IRS Technical Support Division, because there's only really one thing I expect, or two possibilities that I expect the IRS to do. They're either going to, one, return the payment instrument and identify a defect in it, or two, they're going to accept it. And they have 10 days to do either. Okay?
Why do you pick 10 days?
I picked 10 days because in private contract, 72 hours is perfection of the contract.
So you're allowing 3 days for mailing, 3 days for the contract, 3 days for mailing back on a Sunday.
Exactly.
So that comports with commercial law and keeps us safe.
Exactly.
So shorter time would not be fair dealing, would it?
No, it would not. Unless you were using a method like having someone walk into the Technical Support Division of IRS and make presentment of your tender for set-off, then you could do it with, minimum 6-7 days. Or if you did express mail and it got there the very next day, maybe 6-7 days. But in reality, at least 10 days. And if you're sending registered mail, really you're looking at 14 to 20 days, depending on how long it takes your registered mail to arrive at the Technical Support Division of IRS.
Because registered mail goes from hand to hand to hand, and so registered mail actually takes longer than first class, certified, overnight, and everything else, so they really don't have it until it gets there, does it?
Right. Okay? So, once I've done, and what I do to make this a process is, of course, if I was going to do A for V, I would do the same thing as if I were doing any other A for V through the Technical Support Division, where I accept for value the statement, turn the coupon into a money order for the full amount of the outstanding balance on the account. If I were tendering a bonded promissory note, I would make the bonded promissory note at least 125% of the outstanding balance. Meaning, if I owe $1 million on the property, I'm going to make the note for $1,250,000.
Why?
Such to cover any penalties, interest, or fees that are unknown by me. See, when we do the A for V, the language I use on the A for V is it tells the IRS that set the balance to zero, basically. So even if there's a face value to the money order, I include a 1040V with a blank amount on it and a special endorsement on the back of that 1040V so that if there are any additional fees, because the IRS needs to collect a fee for performing the service. And the money order itself made off the statement isn't necessarily going to cover the fees that the Treasury would collect for the service of setting off the account. If there's any additional interest or penalties that exist that are not given or shown on the statement, then the IRS has, because they've been instructed to set the balance to zero, that blank 1040V, and when I say blank, I mean just the amount box on the 1040V is blank. The rest of the 1040V has the taxpayer information in it, and there is a special endorsement I put on the back.
Quick question to back up. You talked about registered mail. Does it need to go registered mail? Because I'm a little confused. Could it go certified mail by the notary?
It can go certified because on this particular presentment, I'm doing it through a notary because I want a record of this presentment.
What about a CFO if I'm sending one to the Visa card CFO and I use a notary presentment? Do I need to use registered or would I be okay with certified?
You're okay with certified. However, whenever you send an instrument like a bond and promissory note, use registered.
So if I was sending the bond and promissory note to the IRS Tech Support Division, or I was sending it to the CFO or to the CFO of the court, that's when I want to use registered mail. Or if I was sending a private record maybe to the judge, but it didn't have a financial instrument, I wouldn't need. I would be fine sending to the judge via certified mail, but if there's a financial instrument in it, that's when I want to use registered mail.
Absolutely. I actually, whenever I'm presenting anything to the private side of judges' chambers, I always send it registered, whether or not there's an instrument in it or not.
So it's just a good idea. I just want a little clarity there, that's all.
Yeah. So now that we've made the first presentment, and remember, because it's a presentment, it's going to have a certificate of service so that the notary is keeping a record of what's being presented. And I also include with that what I call a notice to set off accounts, which is basically telling the IRS, take this tender and set off this account.
Isn't that just essentially an offer?
Yeah. But I'm also instructing them that if there's a defect in the instrument, return the instrument within 10 days. Otherwise, they agree to set off the account.
You're doing that in the cover letter, right?
Yeah, the cover letter I call a notice to set off accounts.
Even with the A for V.
Even with the A for V. Okay? Now I've got a record. Once the 10 days has passed from their receipt of it, or 7 days from their receipt. Why am I saying their receipt of it?
Is not receipt defined as when it's put in the mail?
I'm saying their receipt of it as the USPS reports the delivery of it.
Okay.
So, from delivery. Okay? The reason is because register mail, unknown. It could take 3 days. It could take 8 days. If it takes 8 days, really giving them 10 days is not sufficient. Okay? So I check on the USPS website. This ink's going to make me sneeze.
And that's called USPS Track and Confirm on your computer, and it'll bring it right up.
USPS.com. You can track the register mail number, and it'll give you when it's been delivered. Then I'll give them at least 7 to 8 days from that point to respond or return the instrument identifying a defect in the instrument. After the time has lapsed, the notary will then certify their non-response. I have a certificate of non-response that the notary then issues, and we keep the originals of that certificate of non-response. I don't send anything else to IRS Technical Support Division. If they haven't sent me anything, then they're in agreement to set off the account.
So you don't send like a notice of fault in conjunction with a certificate of non-response?
Nope. I don't send them, and you never send them the certificate of non-response. That is your record. That's not something you send out.
The notary will give it to you.
Exactly.
So you don't even notify the IRS of their fault?
They're not in fault. They're not in fault because why? They had two options.
They didn't respond in 10 days.
Right. They had two options. Acceptance, which means you just do nothing, or return it with a defect. If they didn't return it with a defect, what happened? They accepted it. Okay? So now that they've accepted it, I can get my record from the notary of the non-response. Now, that certificate of non-response, along with a copy of everything that was sent and the original certificate of service, is a record of acceptance of the tender for set-off, right? Okay. I now take copies of that record. Okay? A copy of the certificate of non-response, a copy of the certificate of service, the executed certificate of service with the signature on it, and a copy of the presentment, which would have been my notice to set off accounts, and either a copy of the bond and promissory note or a copy of the A for V and money order and a copy of the 1040V. Okay? I take that record and I put a notice with that called a notice of tender for set-off. And I'm sending that to the CFO of the bank. Along with the record and the notice of tender for set-off, I'm sending them a request regarding a statement of account. If you want to see the details of a request regarding a statement of account, go to UCC Title 9, Section 9210, or 9-210. Okay? The request regarding a statement of account is relevant to collateralized debt. And inform what it is a request to the CFO on behalf of the debtor, identifying the collateral and the account number, and it has on it the debtor's version of the statement of account, meaning the debtor believes that this account is now a zero balance account, right? So the statement of account will also have on it the balance, which, because we've tendered for set-off, the balance is zero. And it's signed. It's a verified document, meaning it's signed under penalty of perjury, something along those lines, okay? Now, under 9210, you must give them 14 days. And the only way the CFO can respond to a request regarding a statement of account is with a verified statement stating that it is something other than what the debtor has alleged the debt to be. So if the debtor is saying that the balance is zero, the CFO must respond with a statement of account stating that it is something other than zero, and they must sign it under penalty of perjury.
Is that noticed in your original request when you sent it into the CFO?
Is what?
Is that notated on your original?
That they have 14 days?
Correct.
Yes, it is.
And you have a sample of that?
I have a sample of that, yeah. A request regarding a statement of account. In fact, I think in Section 9210, they have an example of it too. Either that or they have in there what's required to be on it. Okay? And my example has everything that's required to be on a request regarding a statement of account, including, it's one of the few UCC sections that requires a reference to that section number.
Do you put that in brackets?
I put it in, it may be in brackets, I forget. But it's in there stating that, but because they basically state that it's required to put the UCC section number, I put that in there that pursuant to UCC section 9-210, this is a request regarding a statement of account allowing the alleged creditor to respond within 14 days to the balance shown herein. Okay, that's not the exact language, I'm paraphrasing, but it's basically something along those lines. So, notice of tender for set-off, request regarding statement of account, and a record of the tender itself. which included all the elements of everything I sent to Technical Support Division plus the certificate of non-response. Okay? Once the 14 days has passed, my notary is then going to certify their non-response. Okay? Now, I could do a due process on this particular part, doing a notice of fault, opportunity to cure. But in reality, the request regarding a statement of account, I don't need to do a due process on. If they don't respond within the 14 days, it's established that the balance on that account is now zero.
Because you offered that as an offer that to your records it's zero.
Mm-hmm.
If they don't contest that, it's automatic.
Exactly. But me personally, I would probably do the 3-step process on this. I would probably, because really, this is a claim. And whenever you have a claim, you want to have due process with your claim. Due process is the full 3-step process, meaning step 1, which we just discussed, step 2, notice of fault, opportunity to cure, and step 3, notice of default.
So essentially step 1 might be notice, private, international remedy, demand,
could be
payment, fault, dishonor.
Exactly.
Okay.
So once I've done that and I've gotten my certificates of non-response for each of those steps, that is now a complete record of what? What have I established with that record? The account balance is zero. Pretty cool, huh?
Or is it closed?
It's not closed. The balance is zero. I don't know if accounts ever close. They may be called closed accounts, but doesn't mean that they go away.
And what is a closed account? It's an account defined by blacks that neither additions nor deletions can be made, but yet remains open for set-off.
And adjustments.
So a closed account isn't exactly what you might think it is. Again, language of law requires that you really consider all of the words that he uses. Go look up tender, look up set-off, notice of tender. What is a notice? What is a security interest? Try to get a handle on these words. Get a good handle on settle, because you get set off, settlement, and closure. Understand those 3 words. These are the things you're doing, and it's important you have a good grasp of what you're doing.
Now that complete record, because that complete record includes my entire first step, right? It's everything I've done up until that point is that record, including all the certificates of non-response and everything, right? That's the equivalent of a judicial determination. So I've now got a private judicial determination of an account balance set to zero, and a tender for set-off being accepted for the set-off of that account.
Judicial, you mean there was a judge?
Yeah.
Who was the judge?
The notary.
Ah, okay. So an officer of the Secretary of State's office, or technically the Secretary of State himself.
Mm-hmm.
Oh, interesting.
That first process that you're talking about, settle account, that is the same process you'd use for credit cards too, correct?
This process for setting off a credit card, you could do this.
You could do that.
Now, what would you list as the collateral? Because you must list the collateral on the statement or the request regarding a statement of account. What would you list as the collateral?
Account number?
No, that's one of the other elements that must be there. The account number must be on the request regarding a statement of account, but there must clearly be collateral. Jack, what do you think the collateral might be?
The collateral on what?
The collateral, if we were to do this process, or just a request regarding a statement of account on a credit card debt.
What's the collateral? All of the stuff purchased with the credit card?
Well, the alternative is they may come back with garnishment and everything else, so it could well turn into a judicial case in which they're going to do some kind of a hearing asking for where all of your accounts, collateral, and everything are of the public trust.
Ah. So what is the collateral? The public trust.
Straw man.
The straw man. So I would actually put as the collateral the name, all capital letters, with the 9-digit account number with dashes in it.
The social number.
The social security number. Because the debtor is also identified on the request regarding a statement of account, which is the straw man, name, all capital letters. So I've identified the debtor. Now I'm going to identify the collateral, which is the public account, Brandon A. Adams, 123-45-6789. Oh my gosh, I just gave out my social security number.
Did you?
Okay? So that's, you have a question?
What, in your initial
Microphone.
In your original presentment to the IRS, and you enclose several credit card accounts, i.e. and or mortgages, loans, so forth, in your original presentment, and then you get your certificate of
I wouldn't do that.
so you do a single
I would
presentment.
do a separate one. If I'm settling several different, if I'm using this method, each presentment to the IRS Technical Support Division would be separate. Otherwise, I'm going to have to send each bank all of my, right? Because we have to send them a record of what was sent to IRS. I can't send an incomplete record. Redacted? What, just black lines all the way down the page?
except for the one thing.
No. I do not send redacted records in that because it's a private process. Okay?
And when you send copies, you stamp copy all of them?
It depends. Depends who I'm sending it to. When I send things to judges' chambers, I have my own certified copy stamp. So anything that's not an original that I'm sending to the judge, I flip it over, and on the back I put my certified copy stamp, and I have a seal that I put on there.
Back in front or just back?
Just the back. Okay. So we've now got record of a settled account. So what's step 2? Step 2, perfect the title. So now that I've got an account, and again, we're not going to just walk away at this point and go, oh, okay, everything's fine and dandy, right? Especially if we're dealing with the place I live in, right? I don't want there to be any kind of foreclosure processes starting. So now I'm going to send them a notice. And I'm going to, maybe I might call it a demand for performance. And the structure, the substance within this demand for performance is going to basically state that, okay, there's a zero balance on this account. It's now your duty to reconvey, hold on. If there is already a default, they have 2 duties. Rescind the default, which means they're going to tell the trustee to issue a notice of rescission, which gets recorded in the public records. Okay? That rescinds the default. And if there's already been a trustee sale, it rescinds the trustee sale and the default. Then I'm going to demand that they reconvey or do a full reconveyance of the deed because the account's been settled. That's their duty. Under our contract, once I've settled the account, it's their duty to reconvey the deed. Right? So, and then part of that, the substance of this notice will also state that if you fail in your duties, you are granting and conveying a specific power of attorney for me to execute these on your behalf.
Why did you put that in there?
Well, just in case they don't perform. Remember, this is a volatile situation in that if it is not handled timely, we could lose the property.
So by you putting in the specific POA or power of attorney, you got an agreement to do that because you brought that up. So
Exactly.
You're in a contract mode here, aren't you?
Right. And I'm probably going to do a 3-step process with this, meaning notice of fault, opportunity to cure, notice of default. Because I want to have, again, if I'm going to be executing something under the name Bank of America or any other bank, I want to make sure I've got a complete due process behind them granting to me a specific power of attorney, so that they can't come back later and say, that's fraud, you can't execute documents on behalf of Bank of America. Oh yeah, actually I can. Bank of America granted and conveyed to me a specific power of attorney to execute these documents.
Let me just clarify again, just a short one. You said that second step was notice of default.
You needed some batteries. Man, you must do a lot of talking.
Great. A little clarification. I thought I heard you say notice of fault. And the third step, you used the word default. Big difference between those two words, and I should look those up also, right?
Absolutely.
Because I see those confused a lot, and you can really cause yourself a little harm by using default in your second one, or at least the appearance of wrong. So, okay, good. I just wanted to check on that, Brandon.
Yep. So, now, maybe they'll perform, but like Jack elucidated earlier, most likely they won't, because then all your buddies are going to follow up and do the same thing. Right? So, let's say they don't execute the documents. So now I've got a POA, and I would probably also make this process or give notice of this process once it's completed to the trustee. Because it's the bank is supposed to instruct the trustee.
Is the bank different than the trustee?
Usually.
Okay, just checking.
So, give notice to the trustee that I've got a specific power of attorney, and I may even do, once I've done this process, I may even do this process on the trustee saying, hey, I'm the bank, and I'm telling you, reconvey the property. Or I represent the bank, or I have a specific power of attorney for the bank, and I'm telling you, reconvey the deed, or do a full reconveyance of the deed and file a notice of rescission on the default and or trustee sale, right?
So would that be another demand for performance?
It could be another demand for performance. Or if you notice when you go into your escrow documents, there's the actual documents that the bank would send to the trustee to get the full reconveyance. It's like a request from the bank to the trustee telling them, go ahead and reconvey the deed, or go ahead and rescind the default and trustee sale. So you could just take those documents out of your escrow papers, fill them out as the bank, because you're representing the bank at that point. Okay? If they fail, give them notice of fault, notice of default, and again, I'm going to be getting, what am I going to be achieving with my process with trustee? Creating a record, and what do I want to have at the end of this process?
Due process?
Not only a witness, but it serves as a receipt. But what power do I want? Right, to reconvey the property. So what do I need? A specific power of attorney from the trustee, because it's the trustee who files the full reconveyance of deed with the county, and it's the trustee who files the notice of rescission with the county. So now I've got a specific power of attorney from the trustee to be the trustee. So now I'm the bank and the trustee.
Well, I guess you lose me a little bit. Now, how do I locate or determine who this trustee is?
On your deed of trust.
Okay.
This is the trustee.
Or like for instance, I know Georgia typically have a security deed, not so much a deed of trust.
What's that?
Normally Georgia has like a security deed.
Well, then I guess you're going to have to modify your process, right? Oh.
Yeah, Justin right here went in and changed the trustee right away. Was there an issue with that on how he did it?
Oh, well, hey, did you get a specific power of attorney from the bank?
Actually, I revoked their power of attorney. I went through a different process to the
Okay,
beginning. But
well then it doesn't apply here.
well, actually, through a series of notices and.
But did you get them to grant you a specific power of attorney?
I actually approached it differently, where I revoked the power of attorney. I took the position of the grantor of the loan, and went through the basically the process.
I get that. I know people who are doing that process. I got a problem with that process. You're not honoring the contract.
Right? I'm learning a different approach now.
Yeah. So it's not that it's wrong. I'm not saying it's wrong. I'm not saying it's bad. It's different than what we're discussing here.
Well, the question that Scott was bringing up, and then I'm basically at a point too, is I went through an entire administrative process right up to the point where I changed the trustee, I revoked the power of attorney, and whatnot, and I got everything filed, all the notices of non-responses and everything with the county. And the examiner...
You filed your non-response, certificates of non-response?
Everything.
Okay.
I'm not saying I knew what I was doing.
Okay.
I'm just saying here we are today. But basically, the person leading me through the process before was saying those notices of non-response needed to be tied back with the records, and like I said, this is new. But anyway, where we are today is I got to the point of filing the reconveyance from the trustee, which I had signed to somebody else. So I had him do it, fill out the paperwork, the reconveyance of title, had it notarized like you would, and everything like that. Had a notary presenter to show up to the examiner of titles for a particular county. He wouldn't file it. Flat out refused. I will not do this. Just stonewalled. So I took it in there later, and he wouldn't do it. He just, no.
What were you trying to file? The reconveyance?
The reconveyance. He absolutely refused to file the reconveyance.
And what was his reasoning?
He just says that he's under Torrens law, and he can't make a judicial determination on the owner of the property. And I showed him like the entire... everything that's been done. I said, but
wait. What were you trying to record? Just a reconveyance?
Just a reconveyance.
Are you sure?
Well, yeah, he was going to clear the title of the property.
What's that?
It would have cleared the bank from the title of the property.
Right, but it was a proper reconveyance?
Yeah.
And what was defective about it?
He just flat out refused to do it because he knew he was taking the bank off the title. Because he saw my whole process.
Every time someone pays off a house, the deed gets reconveyed.
Yeah, and he didn't like he saw me do this.
But you didn't actually pay off the house, did you?
No, I went through the process where
I'm sorry, you didn't pay off the obligation, the account.
Not yet.
Now,
I canceled it, but
and also you were in there as the bank or the trustee, right?
No. I was actually bringing the document. I was basically a courier.
Okay. But was the document being executed by the bank or the trustee? Who was executing the document?
The trustee.
I
had reassigned the trustee.
And who was the trustee?
Just so happens it's my father right now.
Yeah, just some dude's name. They're not used to seeing that. Okay? So, not that they shouldn't have filed it. They filed the substitution of trustee. Yeah. Okay. So that's why getting the POA of the trustee, where you can execute the document as the trustee, and then you just mail it into the county because that's probably how the trustees do it.
They actually use like a legal courier service.
Okay. So you use a legal courier service.
I did. And that's when this guy was like, he shows up to do this, and he goes, they wouldn't do it. I mean, this guy he was kind of, I shouldn't say didn't have a backbone, but he's like, well, he didn't understand what I was asking him to do because it was clearly out of the ordinary. I might be the first person in Minnesota to ever do this, And
so how do you know that the trustees typically use this guy?
I don't.
Exactly. So why don't you just mail it into the county like a trustee would, from the trustee? See, the thing is, and you said you filed a whole bunch of other stuff on the property?
Yeah,
Yeah.
The process
They're looking at the title on your house going, oh, there's some crazy shit going on in this property.
Oh, it's
That's
awesome.
why they refused it. That's why I'm saying keep your stuff private. You start filing all this crazy stuff into the county on your property that doesn't look like it should be there. It doesn't have their form. You're hurting yourself. Because let's say you want to sell the property down the line, you aren't going to get title insurance with all those crazy filings on there. It needs to look like everyone else who's cleared their account. Reconveyance. And if, now let's go back. Because let's say you don't have the time to do a process with the trustee, to get the trustee to grant you a specific power of attorney, to execute the reconveyance and the notice of rescission. But you've already established that you have a specific power of attorney for the bank. What can the bank do? Substitute the trustee. So then you could do a substitution of trustee. Don't use the homeowner name as the new trustee, okay?
It's better to use a trust, or some kind of
Or a company with the name trustee in it. Right? Or DBA. Go file a DBA with the county. Mike Smith doing business as All American Trustees Company. Right? Okay. So, and then once we've done this, now we execute the documents. We execute the notice of rescission if the property is in default or has had a trustee sale, and we execute the full reconveyance of deed. What have we done now? Perfected our title. So now we've settled the account and we've perfected the title. Now, if you've lost possession, now you're going to go about gaining possession of the property. If you're in possession of the property, do you need to do anything about the possession? No, you're in possession. But you need to be mindful of these processes and administrative process in general. This is not for beginners, this process. You need to do a lot of studying to do these processes, because what if they continue to move forward with the foreclosure anyways? You better rebut any presumptions and respond to every step of their process. If you continue to get statements of account, what happens if you hold on to a statement of account for 30 days? Validation of debt. Okay? So be mindful that anything you receive in relation to the account or the title, foreclosure, anything that comes in after you've perfected the account and the title, you better respond. And it better be a meaningful response that rebuts any presumptions that their process is making. Okay? So if you've lost possession and you've settled the account and perfected the title, well, now you're going to give the bank a notice to vacate. 3-day notice. Where are you going to send the notice to vacate to? Nope. You guys, this is a public process. Nope. Nope. What's that? You can post it on the property, that's one, but is that sufficient notice?
No.
Who are you going to mail it to? No. If somebody's in the house, you guys don't do this. If they've actually sold it to a family and they're living there, I mean, come on, really? Do another process to regain your loss, okay? But don't go kicking regular people out of their house. I'm saying if the bank sold it to themselves and the property's abandoned, do this. If you guys go around kicking people out of their houses, you're no better than any of the banks. It's not very compassionate. Not to say you don't have a right to. But what you could do is give them notice that they're going to be paying rent to you. Right? So, if they're in fact, because sometimes the bank will rent the property. Right? So you got to establish, look at the title. If it's already gone through trustee sale, see what the latest title documents on that property are. Because if the bank is still the registered owner, then they're either renting it or it's abandoned. Okay? My notice to vacate, my 3-day notice, needs to go to the public side of the corporation. Nobody here knows how to serve the public side of the corporation? What? How do you serve it? How do you serve a corporation?
There's an agent registered with the state.
Ah, Gordon knows. Registered agent. Agent of service, it's also known as. If you go to the Secretary of State records for that corporation, it's going to show you a special name and address of the registered agent or the agent of service.
That's a person who accepts service and every corporation has to have an agent to accept service in that state.
Okay? So that's where you're going to send your notice to vacate. And I would also go pin it to the door. That's if the corporation owns it. Yeah,
yes.
Don't kick families out of homes.
Every corporation, yes.
Okay. What's that?
The bank took it back to themselves, sold it to themselves.
Yeah,
They are a corporation.
exactly. They are. Okay, so step 2, after the 3-day notice goes in, and you've waited at least 3 days, 3 days beyond their delivery of it, you want to give them sufficient time to respond. But they only have 72 hours to respond. Then you go file an unlawful detainer or a complaint for unlawful detainer. There's 2 things you must have, 2 witnesses you must bring with you to your unlawful detainer case. What I suggest is go watch a couple of them. There's plenty going on right now. You can sit there for 8 hours in court and watch unlawful detainer after unlawful detainer after unlawful detainer. Go to the court, ask them which department are the unlawful detainers being held in. And go sit there and watch, because every attorney does it the same. There's 2 witnesses. One witness is going to say, and what I would do is write down the questions that the attorney asks his witnesses. Write down the process that the attorney does, and then mimic it. Good afternoon, Your Honor. So-and-so here for the plaintiff. Unlawful detainer on Bank of America. I've got my witnesses. And then you bring your witness up, and you ask the same questions an attorney would ask. On such and such a date, did you serve the 3-day notice? Yes, you did. Yes, I did. How did you serve it? I mailed it to the agent of service. Do you have a record of that? Yes, I do, Your Honor. I'd like to present evidence of the record of service. How else did you serve it? I pinned it on the door. And at what date did you do that? On such and such a date. Your Honor, evidence of service on the door. Then I bring my second witness up. Did you serve the summons for complaint of unlawful detainer? Yes, I did. On which date did you do that? On this date. Your Honor, I'd like to submit into evidence. Actually, that'll already be in evidence because the proof of service must be filed with your unlawful detainer complaint before the hearing. So your proof of service on the unlawful detainer will already be in the case, but you still bring your witness to say, yep, I served the unlawful detainer.
If I have a girl witness, does she have to go, and yes, I did, Your Honor?
Absolutely. Okay, so then what's the judge going to do? He's going to go, bing. And guess what? People have done this. Guess how many times the bank has shown up to the unlawful detainer hearing? 0. So we get our summary judgment right there. Judge goes, okay, I find for the plaintiff. Then you get your writ of possession from the judge. What do you do with your writ of possession from the judge? You take it to the sheriff. And you say, I'm kicking Bank of America out of my house. Or out of my house. And they go, you're kicking the bank out? And then they're thinking, I wonder if I could do that. And then a couple days later, 5 to 10 days later, sheriff comes back. Here's the keys to your new house. Thank you very much. And now I've got a settled account, a perfected title, and possession, and thus a perfected security interest. Okay? Now, I may also at that point file some other encumbrance to protect my interests so that it'll predate any and all other encumbrances that may be tried to file on this property. Even though I've already got one in the form of a grant deed, I may set up a new deed of trust. And I may assign a trustee. I'll assign myself as the beneficiary and grantor and appoint Gordon here as my trustee. Maybe not Gordon.
Trust me.
Okay? Seems simple enough? All righty. We're going to take, we have a couple more questions, then we're going to take a break.
Got a mic coming your way. And that was a good point you brought up, Jim, because individuals are not required to have an agent for service in the state. That's only for corporations.
Yes.
Gordon, recently I just went to a seminar where there's a new federal law that was just passed regarding mortgage foreclosures, which stipulated you have to honor lease agreements that's on record, or you have to at least give them a 90-day notice to vacate a property based upon a foreclosure process.
Right.
Is your process, you're going into the public side, therefore are you going to have to abide? I would assume you would abide
if
by
there's
that.
someone leasing the property.
Pardon?
If there's someone leasing the property.
Correct, right.
You're going to give them notice and you're going to be collecting the rent.
Right. If anything in this process must be done in accordance with the statutes of your state. See, I've just given you what I know about California. I don't know how the 3-day notice unlawful detainer writ of possession process works in any other state.
Right, but there's
I just haven't had the time to do the research.
But there's a new federal law that covers all the states on that 90-day period.
Yeah, which is, in California, there was already a 60-day period.
Georgia's 90 days.
See, in Georgia already had a 90-day.
But you would want to be fair to any tenant anyway. 90 days
if there's
not...
a tenant and they're leasing, you want to be fair. And actually, you may not want them to vacate. You may just say, hey, you're going to be paying rent to me in 60 days. Or after I've perfected the unlawful detainer. So you don't have to leave. This notice is for the bank. Right. So when I take possession, you're going to be paying rent to me.
Back to the perfecting the title. If someone's current on their mortgage, how would you do that then?
Say that again?
If someone's current on their mortgage,
they're
making their payments,
right,
and they're going to perfect the title, are they going to...
Well, first they have to settle the account.
Okay, they already settled the account. They're at step 2, perfect the title.
Okay, well, you said they're still making payments. That means the account's not settled.
So they stop making payments.
After they settle the account.
Okay, they settled the account. They've been
if they make a payment after the account's settled, then they've recontracted.
Okay, so that's what I want to know. When they stop making, they're not in any foreclosure, they want to stop making payments. After they settle the account and they've done that process and perfected it, then they would not make another payment.
Why would you make a payment if you settle
Because
the account?
some people's jobs would pertain to their credit, and they need to make sure their credit.
Well, they don't believe their process worked then, did they?
Yeah. If that's your concern. Now, if a mark goes on your credit, you got a claim. Because you've got all these look at all the records we've perfected in support of our process at this point.
Do you think notifying the credit reporting agency would be any different for an erroneous thing put on there? No. You would provide them your evidence, do a 1, 2, 3 step, and Experian, the rest of those people will also remove that off their credit.
Okay. So you just, okay.
Due
Again,
process with
remember,
them.
this is not for beginners. Okay? Okay, we got microphone. You got a microphone? Okay, go ahead.
Push it up.
Okay. On the specific power of attorney, you're really getting that by default, is that right? Because they are not responding. Mm-hmm. Are you offering us some kind of form that we can follow? I mean, isn't that going to look like something kind of irregular?
It's just in the wording of my demand, my notice.
But
remember, I had a, what did I call it? Demand for performance?
Right.
I'm going to have the wording in my demand for performance saying, if you do not perform within said amount of days, you will be granting and conveying to me a specific power of attorney to execute these documents on your behalf. That's it. That is the specific power of attorney.
Right, I get it. But what are the documents that you actually file in order for the reconveyance? I mean,
it's called a full reconveyance of deed. And if you're already in default, you're also going to file what's called a notice of rescission. Now, take a step backwards. If you're already in default or there's already been a trustee sale, the notice of rescission goes first.
Okay, got it.
Then the full reconveyance of deed. If there isn't a default or a trustee sale, then it's just a full reconveyance of deed.
And are those documents going to be part of your download package?
No, they're standardized.
There's something that you could look up on the web and fill in the blank. And then when you say file those, you're talking about recording them in the county recorder's office.
Right.
And that is sufficient?
Yes.
Okay, cool.
Absolutely. Because I believe those documents also reference the deed of trust. So you're going to have to reference the deed of trust that you had with that bank. But remember, you're executing on their behalf. So it's going to be in accordance. It should look like any other full reconveyance. If there's a notice of rescission, it should look like any other notice of rescission.
I have a question. I think you lost me because I think you was talking about as if you were in the property, how you would take control of the property, and then it seems like at the end you.
No. Listen, if you have possession, you already control possession. Okay. So you don't have to do anything. You don't have to do an unlawful detainer on yourself. Okay.
So then, in what condition would you do?
Speak into the mic.
Yeah, I can't hear you.
And what circumstance would you do the
Mic's
other one?
What circumstance would I do what?
The other one in regards to someone is in the
property.
property.
Other what? The other one.
That is the settlement account, the notice of tender, the notice to vacate, the unlawful detainer, and the writ of possession.
Okay. I'm not understanding the question.
Okay. I guess
because you're saying all of these things.
Okay.
You're saying what situation?
In regards to like control the possessions.
Okay. This step 3.
Right.
If you don't have possession, you got to get possession.
Okay.
That's what that.
And that
if you already have possession, you already control through possession.
Okay. So if I'm trying to get possession of a property, is that like me driving down the street and seeing a house that I like and?
If it's abandoned. If it's abandoned, yeah.
Okay.
But that's a whole other process because you don't know anything about the account on that one.
Right.
What you would do is you would do a claim, like a private administrative process, where as my brother's keeper and guardian of my community, I see that you're harming my community by having a vacant house in my community. Here's your opportunity. Right? Like if I like in Southern California, there's tent cities where people are living in tents because they've all lost their houses. I can go around to every abandoned property in my neighborhood and take it away from the bank because they're injuring my community and I'm my brother's keeper. And I can give each family in a tent a house. Or I could just look at the records of that property and see who got kicked out of this house. And I'm going to notify them, hey, I'm going to take your property back for you. Give me your account information.
Would you do
yes, let's do that.
Yeah. That's why we're doing the Mastery in Commerce course. Because I can't go around saving everybody. But if I got 100 people doing this, we could save some people.
Amen.
What's that?
I said amen.
Amen. Hallelujah. What's that? No, it's a 7-month program. Maybe, well, next year, I will be doing it all over the country. Well, actually, not I, but all the graduates of the Mastering Commerce from this year will be doing it all over the country. We'll be doing 7-month programs in Atlanta, New York, Florida, Texas, Ohio, North Carolina. As long as I get 50 people to show up, we'll be doing it everywhere. And I volunteer to do Hawaii.
Okay, Brandon.
I'd like to have a 7-month vacation in Hawaii.
Okay, just be patient with me because I'm a beginner on this one.
I try to be patient with everyone.
Okay. Now, I totally got lost, but what I was trying to accomplish was A4Ving perhaps, my mortgage account.
Mm-hmm.
That's it.
What do you mean that's it?
Because that's all I thought that you had to do to A4 to settle the account.
Right. So you're only going to settle the account and you're not going to perfect the title.
Well, I don't know. I thought that if
well, okay, you can go ahead and settle the account, but ask the people around you who have already done that.
It's not going to get you ownership of your home.
See what their experience has been about the rest of the foreclosure. Because it just keeps on going. Even though you settled the account, the bank's going to continue to move forward with the foreclosure process.
If you don't want to have problem with your home and you want to maintain it, you're going to have 3 parts that have to be attended to, is what he's telling you. You can't just do this one. You're going to need to perfect the title. And if you don't have, well, you got to control possession, whether you're currently in it or whether you're going to have to go through the process to obtain via unlawful detainer, etc.
So if you're not in foreclosure and all you just want to do is just...
Then you still have to do these 2.
You have to do 2.
You have to settle the account and you have to perfect the title. Because if all you do is settle the account, they still have an encumbrance on your property and they're still going to move forward with the foreclosure process. So yeah, you settled the account, but in 6 months, you're going to be on your ass in the street.
Why would they be moving forward with the foreclosure process?
Jack? Why would they move forward with the foreclosure process?
They're not going to make it simple for you. It's not going to go down that way. This is not, again, a process for amateurs because there's a little bit of process to it. And if they made it easy, what do you think would happen? Wouldn't everybody just do it? And what would anybody learn? For all of you to learn this, you're going to have to elevate your enlightenment to some degree, including but not limited to being a creditor type. This is not for debtor types. This is not a process for you to get over. This is a process to understand, internalize, and then manifest itself in a genuine love for your brother when you do this. So this is what part of what you're being taught here is to become a creditor, which is attitude. And if your attitude is correct, then you're going to desire to learn. One, you're going to settle the account. Why can't I just settle it? Why do I have to go perfect the title? Because it's part of the game.
I don't mind. I just didn't understand if I'm not in that situation, but I do want to gain peace. I could see that coming down the road.
But do you understand now, though?
If you want peace when you're home...
Now that we've explained what's going to happen after you settle the account, do you understand why you would do perfecting the title?
I really don't fully understand what happens. I mean, because you set off, you got a
if
zero
you don't
balance.
perfect the title, you have an imperfect title and you will not have the home.
Okay. Let's say you settle the account, right? If they move forward and they do the reconveyance and they do the notice of rescission and everything else, then you got nothing else to do. However, don't count on it. As a creditor, you're moving your remedy. You're not sitting back waiting for someone else to do your remedy for you.
And they're going to keep sending statements to you to make payments.
Right, and if they keep sending you statements, you think they recognize that you settled the account? Right. Now let's say all of a sudden your statements stop after you settle your account and you get a notice of reconveyance. Perfect, it worked. But again, don't count on it. Well, I'm going to put these up on the wall if you want to copy them. Go ahead.
In regard to
you guys are cutting into my dinner time. So
the gentleman, when he was saying he was trying to file some paperwork and they wouldn't take it, I had a familiar experience when I was filing paperwork with the county, the Register of Deeds, and they wouldn't take my paperwork, and so I came back and I sought some advice, and if you put it in under an exhibit, which when I went back and I put it in an exhibit form.
Whoa. What were you trying to file?
I changed the title on the home.
In what form did you change the title?
Through administrative publication, let it cure for 30 days, which I'm changing my process.
Okay.
But this process did work.
Okay, now he's telling you how to get things recorded that you don't want recorded, right?
Well, that's true.
Just so you know, this is how you record things that you don't want to record. Because in reality, the only things you should be recording in this whole process are, if you're in default, a notice of rescission. If you're not in default, if you're in default, or whether you are or not in default, a full reconveyance of deed. That's the only two things that are going to get filed. Or if you're going to substitute the trustee, a substitution of trustee. That's it. Those are forms that every county recorder is used to seeing. Don't try to record your administrative process into the public record. You're negating it.
It wasn't the administrative process. We had actually changed title into a corporation name, and we were recording a new deed.
So you're recording a grant deed?
A new deed, that's
okay.
Correct. And still they didn't want to do it, and we had to ask for the supervisor, and then the supervisor came, and at that point they did it.
You need to check they have a book on the forms and the things, and oftentimes a lot of people leave out the standard stuff that's required in their form, and you'll find that if it comports exactly as required, you probably won't have any trouble. And I couldn't tell you if that exactly comported with what their local book requires or that county requires, but when you actually go get a county book for that particular county and see what's required in those, and go perhaps even pull out a recently filed one from some bank, you may find that yours is a little different and might require a little bit because they're not going to stop the filing of a new owner, of a grant deed, or a quick claim interest. That doesn't make any sense.
No, and you're correct, because it had to be on the right size paper and form, and so there was all that involved.
All right, go ahead.
At what time, or at what point prior to the perfected security interest or after do you think that there would be any risk of, like, say, the bank retaliating and suing you and bringing it into the judicial process? Or have you had any experience with that?
I haven't seen them.
So as long as you're just following this, then...
Now, I'm not saying they won't, but if they do, are you worried? We know how to operate on the private side of the court, don't we? And you've got a pretty complete record, don't you?
And that's going to get submitted to the judge in chambers, isn't it? We went through that earlier today. And again, this is not easy for you all to assimilate so much data, but as you pick up the tapes from this particular session and go over it half a dozen times in meeting groups and practice some of this stuff, you're going to get very proficient at it.
My question is, say for instance, I lost the property, it got foreclosed, got taken 3 months ago. Is there a certain period of time that lapsed where it might not be worth it to go back after the property? Even if, say for instance, the bank took it back, they're vacant.
I would say, is there a family in the home?
No, no.
If it's still abandoned, go after it.
Okay.
It was 10 years ago. If it's been abandoned for 3 years, it may be, you may not have to do any of this process. You could just say, hey, I'm taking this abandoned property. It's been abandoned for 3 years. I shouldn't have said that.
Well, yeah, but no, the key...
That's beyond this group.
No, the whole point of what I'm just wanted to get is that understanding the process that you just outlined.
Right.
And saying, hey, you know what? I just lost this property a couple of months ago, or whatever the case may be. I just wanted to confirm whether there's a time frame that it makes sense or maybe doesn't make sense to pursue going after the property, especially if the property has not been, no one's occupying the property?
Well, if you're concerned about statute, which I'm not, but if you are, you may want to look at what's the redemption period for your state. Some states have a 3-year redemption period. Some states have a 1-year redemption period. Some states have a 3-month redemption period.
Okay. Just want to know if you're familiar with anything around that. That's all.
Yeah. Okay.
If I have MERS on my warranty deed and I have another company sending me a letter saying they're my new mortgage company because the previous one is in bankruptcy, in my perfection of title, who am I sending my presentment to, my certificate of non-response? Which CFO is getting it? Is it MERS or is it
He's saying he's going to send his certificate of non-response to somebody?
That's what I heard.
A copy of it.
Come here. Come here.
Come on, Rourke.
Are you going to send? Are you really going to send your certificate of non-response to anybody?
That's your private record, Rourke.
Did I use the wrong word?
Did you?
I'm still thinking about the question.
Did you not ask who you're going to send your certificate of non-response
Oh,
to?
who are you going to send your presentment to?
Yeah.
Oh, okay. Who's the relevant party?
MERS.
Are you sure?
I'm not. That's why I'm asking.
Okay. So you're saying MERS is named as what?
They're on the warranty deed.
As what? If it's MERS, chances are they're a nominee.
Oh, they are the nominee lender.
Yeah, or nominee beneficiary.
Okay.
So
the nominee beneficiary.
we're not concerned with nominees. They have no interest. Right?
Right.
So we're concerned with who's got an interest on the property. Okay?
It's not the loan servicer, but the loan firm, the actual mortgage company.
Yeah.
The new company says they're the servicer.
Okay, so they're a servicer. Who's going to... Now, not to say you shouldn't give them notice because they are a nominee, but in reality, the bank still has to... the servicer should be included in the process. If the servicer is not who the obligation is actually owed to, you're going to be doing your process with the bank that is supposedly has the interest in the property. But if there's a separate servicing company, you're going to be giving them notice of everything you're doing with the bank. Okay?
So I A4V to the IRS the mortgage, and I send a presentment to Washington, and I have a certificate of non-response from my notary, and that presentment to the IRS, correct?
Right.
And then when I send the letter to the CFO, why am I not including a copy of that certificate of non-response?
You are.
So why was I getting rebutted on my sending my certificate of non-response to the CFO?
Because that's all you said, was you were sending a certificate of non-response.
Oh, I got too busy with the question when I didn't
No,
finish.
that is
in my presentment to the CFO, in which it does include the certificate of non-response from the IRS.
And it's a copy.
Yeah,
It's
so
a
I was
copy,
50% right and 50% wrong.
and it's only one tiny part of the record.
Yeah, right.
Okay. So, yeah. So, you've escaped punishment. All right. We're going to wrap for dinner. And